call the meeting to order.
So what we're going to do is
Ask everyone to please take their seats. Est-ce que je peux demander à tout le monde de siéger, s'il vous plaît? On est prêt à commencer.
Ready to begin the session?
So, ladies and gentlemen, I'd like to call this meeting of the Standing Committee on Justice and Human Rights to order as we continue our work in doing our clause-by-clause review of Bill C-14. We are currently, I believe, at page number 88 in the legislative package that we received, which would be CPC 21. I would note that just for everybody's information, NDP 4.1 that we started to deal with this morning will be deferred as it wasn't in the appropriate section until we get to Liberal 8. And then NDP 4.1 will be put forward in a different way thanks to the collaborative work of all three parties before Liberal 8. So good job, everyone. And we'll move to Mr. Vierson's proposal, CPC 21. I'd ask if Mr. Falk would be willing to move it so Mr. Vierson can speak to it, if he's here.
He's right here.
Ah, you're at the other side of the table this morning.
He's been promoted.
Exactly. Mr. Vierson, please go ahead.
Thank you, Mr. Chair. It's sitting with the friendly company over here. This motion or amendment is to deal with doctors financially benefiting from providing assistance in dying or assisted suicide or euthanasia, however you want to term it. We really felt that out of the, if this service is to be provided, it should be provided out of purely altruistic motives, and therefore we felt that there should be no material benefit for performing this this act of killing somebody, seeing as it is such a profound act. So that is, we felt that if this act is indeed driven out of altruistic motive, there should be only altruistic motive as the motive. So thank you for the opportunity to speak to it, and that's my...
Thank you very much. Again, Mr. Vierson, I want to just ask the question. For receivability, wouldn't it be up to the provinces to set a fee schedule for any medical act? Does the federal government have the power to tell a province they can't set a fee schedule for anything that is a medical act? I mean, have you thought about that?
Yeah, for sure. And this comes back to, I guess, my initial amendment that I brought to the very first amendment we addressed, and the fact that I did feel that it was this shouldn't be healthcare. This should be outside of the realm of healthcare. This may be announced too late, perhaps, but it is. I do think that we need to ensure that the viability of our healthcare system, people's trust in our healthcare system, must be maintained, and I do think that this would be a great way. One of the ways that we can ensure that people are confident that when they go to the hospital, they will be treated with the utmost of respect and care.
No, and I do understand, and from a substantive public policy ground, I understand. May I ask the officials from the Department of Health, does the federal government have any powers to not require, to not allow a province or territory to set a fee under Medicare or anything else if this is a medical act?
No, we don't.
I'm going to have to rule this out of order as not receivable because it's not within the competence, I believe, of the federal government. I'm sorry, Mr. Pearson. We'll move to CPC, I'm on the wrong number, CPC 22, but Mr. Kamich, but it's identical to CPC 21, so I would have the same ruling.
Okay, he did prepare a statement for me to read. I don't know if I can do that or not.
If you, I mean, again, it's out of order, but is it a very long statement? Can we ask maybe Mr. Kamich to email the statement to the members of the committee instead of reading it out? Just because, again, it's not in order.
All right.
I'm sorry. PV 10, Ms. May.
Thank you, Mr. Chair.
Or pass it out.
Most of my amendments to this point have come directly from evidence and witness recommendations that you had before you. This comes from concerns that were raised by witnesses, but no one actually put forward this exact language. I sort of thought this up myself, and I put it to you that here's the circumstance, and we've heard it discussed even in clause by clause. What of people who are in a small and remote community? You have two problems. You have people who may be related to each other as they are in small practices, may know each other, and it may be difficult to find independent health professionals to provide a truly independent written opinion. Knowing from friends of mine who are medical practitioners in remote communities that they quite often use video consults, I wanted to make this possible under the law. Now, it may be that this could be taken as implied and they could use video consults to attain consent, but I felt it was worth inserting subclause 6(1) to say that in communities where it is not possible to find another independent medical practitioner or nurse practitioner to provide the written opinion referred to in paragraph 3E, the opinion may be provided by recorded video conference by another independent practitioner or nurse practitioner from elsewhere in Canada. I hope this addresses the problem that was raised by quite a few witnesses.
I'm just going to read in that you meant to say independent medical practitioner in the second of last line as opposed to, because otherwise it wouldn't be consistent. So let's just, if we can deem that word was there.
Thank you very much. That's a drafting typo. Thank you.
Yeah. Debate? Mr. Fraser.
Thank you, and I understand the intention of it and respect the intention of it. I do have a concern that it would be infringing on provincial and territorial competency in order to deal with the issue, and I know that our government has stated that they are certainly interested in working collaboratively with the provinces and territories in having a pan-Canadian approach, but there may be some issues with regard to a Canadian in one province under different jurisdiction, and so I'd worry about that. I also note, and Ms. May alluded to it, the fact that there's nothing in the Act preventing this now that would make this impossible. So for those reasons, I don't support the amendment, even though I do respect the intentions.
Debate, discussion? If not, can I just ask the officials, can you clarify that there's nothing in the Act that restricts it by video conference?
There's absolutely nothing in the legislation that requires a physical examination of the patient by the doctors. There is a requirement for a written second opinion, but nothing requires the physical presence of the practitioner with the patient.
Okay. So
or the two practitioners to be together.
Thank you. So, Ms. May, I'm going to go back to you for closing.
I know I can't move amendments to my own motions at this point because they had to be in 48 hours ago, and I'm wondering if Mr. Fraser might consider changing it from elsewhere in Canada from elsewhere within the same jurisdiction. That would avoid any issues vis-a-vis the provinces or territories in which a medical practitioner or a nurse practitioner was licensed. So I asked the question. Otherwise, I suggest that this would allay a lot of concerns for people living in remote areas where it is hard to access, independent of each other, more than one medical practitioner, more than one nurse practitioner.
Well, I agree that would be more satisfactory, but I don't think it would be satisfactory enough for me to support the amendment. I do believe that it would still be up to the ministers of health across the country, federal and provincial working and territorial working together. I note as well, based on the information from the department, that nothing would not allow this now. So I think it'd be better not to play around with that wording.
However, as chair, I had the discretion to let you move the motion however you say you want to move the motion. So I'm okay with you moving the motion using the words nurse practitioner or within the same province or territory or within the same jurisdiction if you want to.
Mr. Chair, as that would cause us to have to vote on the sub-motion and then vote on the main motion, and I don't think it would make any difference in the end. In the interests of the committee's time, I'll accept that we put it to a vote as it was written.
Okay. Thank you very much, Ms. May. So this is on PV10. All those in favor? All those opposed? Unanimously not adopted or unanimously disapproved. We'll move now to CPC 23. Mr. Cooper.
Thank you, Mr. Chair. Very simply, this amendment would provide conscience protections for medical health professionals as well as health institutions. It is important that everyone's charter rights are respected. The charter rights of patients who have the right to access physician-assisted dying, but also the charter rights of health professionals, freedom of conscience, freedom of religion. These rights under Section 2 of the Charter are not just any charter rights, they are fundamental freedoms. And I think that there is certainly a need for consistency, and that would be what this amendment would provide. It is analogous to legislation that is already on the books, and that is Section 3.1 of the Civil Marriage Act.
Thank you very much, Mr. Cooper. Mr. Biddle, then Mr. Fraser.
Thank you, Mr. Chair. I have serious concerns about this and explicitly granting conscience rights to institutions, especially since these institutions will be publicly funded. These institutions are not analogous to institutions under the Civil Marriage Act because those are churches. These are publicly funded institutions. And it may be that the only institution in a community is a religious-based institution, and I don't see how this meets what we're trying to accomplish. Furthermore, there's no court case, and I believe I've asked witnesses, no court case apart from a minority decision in a Supreme Court case that refers to a private Catholic school. There's no case where the Supreme Court has granted conscience rights to a publicly funded institution.
Thank you very much, Mr. Biddle. Mr. Fraser.
Yeah, I agree with that. But the only thing I would add is that with regard to individuals, we will be dealing with that in a moment on another amendment that will be brought forward with the collaboration of the work from committees from all parties, or members from all parties.
Yeah, and I just want to, again, thank Mr. Cooper, Mr. Rankin, and Mr. Fraser for working together so collaboratively on what will come forward, regardless of how this one is dealt with. Is there any further debate? Mr. Nicholson.
Mr. Cooper raises a very good point that these institutions that are motivated or bound by certain philosophies or religions and everything else could find themselves exposed. And I think this is exactly what he's targeting here, that just because there's only one or two cases or a minority report or minority decision that's directed at a religious institution doesn't mean that this isn't going to be something that we will have to look at in the future. And I'd like us to do the right thing now and protect those institutions that will have a problem with this. And so I think I'm hoping that the members of the committee will join together and give that protection to everybody, not just the individuals, but the institutions as well.
Thank you very much. Mr. Falk? Mr. Nicholson?
Did you want to go the other way?
McKinnon next. Oh, thank you. Mr. McKinnon, then Mr. Falk. See, when I'm looking this way, I see this first.
Keep looking this way.
I'd just like to respond to Mr. Nicholson. Institutions are not individuals, they're not people. They don't have rights under the Charter. So I side with Mr. Fraser's argument that we can't be talking about rights of institutions in this context. So I will not be supporting this amendment.
Mr. Falk.
I think Mr. Cooper has raised a very, very important issue with this amendment. It is by far one of the most predominant issues that filled our time with our witnesses. And I think institutional conscience falls into, in this particular case, falls into the very same category as individual conscience, because many of these hospitals that we have right across our country were originally founded by faith-based organizations, and they're continually run. Their board of administrators, or their board of directors and administrators are still faith-based and make decisions for that institution from a faith-based perspective. And I think we need to respect that. We wouldn't have these institutions here today that provide these services if it wasn't for these faith-based organizations that initiated them. And I think this just affords them the protection that they need to have to operate in a consciously driven organization, and I think they deserve it. They've earned this.
Thank you very much. We've had 3 Conservative speakers. Let me just see if there's anybody else that wishes to speak on this side. Anybody else? Mr. Genis, you have something to add? I'll let you very briefly add something.
I just want to say that aside from the philosophical questions here, there's a real practical risk to not protecting the rights of institutions. I mean, there are cases internationally where a failure to protect the conscience rights of religious-based charitable institutions has led to those institutions closing. And I'm very worried that we'll get into the same situation when it comes to Catholic hospitals, Catholic healthcare institutions. That's a big cost. So even if you don't agree with conscience rights for institutions philosophically, I'd ask members to think about the cost for patients and in terms of access to other services that would result if many of these healthcare facilities cease to operate.
Thank you very much. Mr. McKinnon?
I just wanted to respond again that while I take the point about the concern for institutions and how they operate and how they need to have the freedom to do so, no individual who acts within these organizations, whether it's a director, a doctor, a nurse, whomever, is compelled to provide services under this act. So by protecting the rights of the individuals, I suppose would indirectly be protecting the institutions. So that would be my point.
Any further discussion? I'm going to go back to Mr. Cooper to give him a chance to sum up the arguments and close.
Institutions are not people and therefore do not have charter rights. It should be noted that Chief Justice McLaughlin in the Loyola decision did specifically say that the charter rights under Section 2, freedom of religion, freedom of conscience of individuals and institutions are intertwined. So it is a very real issue. I know that health institutions have expressed significant concern, and I think it is important that we provide those institutions who provide high-quality health services in many parts of our country with the protection that they have asked for. There is nothing that this amendment would do which would preclude access to medical assistance in dying for patients who wish to access it.
Thank you very much. I think it was well argued on both sides. Now we're going to get to the vote. So those in favor of CPC 23? Those opposed to CPC 23? Defeated. Which now brings us back to NDP 4.1 and Lib 8, which are the, I think, joint product now of the working group that was created.
Right, and I'd like to salute Mr. Cooper and Mr. Fraser. This is definitely a joint effort. And Mr. Chair, it's in 2 parts. The main part, which I think has been distributed, it's a handwritten page, very similar to Mr. Fraser's, but with a couple of key changes. Has that been distributed, Mr. Clerk?
Maybe what's happening is he's not giving me when you...
And so the suggestion was that after line 2 on page 8, for greater certainty, nothing in this section compels an individual to provide or assist in providing medical assistance in dying. So the phrase medical assistance in dying, of course, is already defined. You'll note it deals with an individual. I can just foreshadow that there will also be an amendment proposed to the preamble that will make explicit reference, as you'll see in the next page, to the Charter and nothing affecting the guarantees of freedom of conscience and religion in the Charter. I know we're not talking about that, but I think people need to know that that reference will be made as part of this package that we've agreed to.
What I need, before we get to debate, I need to say as chair, because right now we're only dealing with this specific motion, while you can say that this is what you intend to propose, there can be no link between one and the other.
Correct.
So I just want to make sure that everybody's debating the motion on the floor, which is after line 2 on page 8 page.
Thank you.
Would you like to further expand, Mr. Rankin, on anything, or?
No, I would just echo some of the comments made in the debate over the last motion by Mr. Cooper. We heard enormous testimony, both at the joint panel and at the Justice Committee hearings, on the need to find some way to provide comfort to people who have freedom of religion or freedom of conscience reasons for not wishing to participate in any way, shape, or form in this procedure. This is an attempt to make sure that people don't feel that there's any compulsion to do so, either directly or indirectly, assisting in providing it or doing it themselves. So that was the objective of the proposed amendment.
Thank you very much, Mr. Rankin. Mr. Fraser.
Thank you very much. I do appreciate Mr. Cooper and Mr. Rankin working on this with me to come up with language that was satisfactory to the three of us and hopefully for the entire committee. I do think it is important from the testimony we heard and from the evidence we heard that it perhaps was an issue that people felt that maybe their conscience rights weren't being protected as adequately as they could be. All along, I have agreed with the minister's position that nothing in the Act, of course, compels. So this, for greater certainty, puts it in there. We'll work on language in the preamble as well that hopefully will get adopted and be able to make this absolutely certain. I do think the language is adequate in order to not stray into territory that could potentially cause problems constitutionally, and therefore I'm definitely supporting this amendment. Thank you.
Thank you very much, Mr. Fraser. Mr. Casey.
Thank you, Mr. Chair. I just wanted to point out that the government's position on this is informed in large measure by the excellent work that's being done over in the Senate in their pre-study. And that was certainly a part of the reason for the government's support of this motion. Thank you.
All right. Well, thank you very much, Mr. Casey. Any further discussion? Mr. Falk?
Yeah, I'd like to propose a sub-amendment. After the word assist, I'd like to add either directly or indirectly, because I believe that's what I heard Mr. Rankin say, in providing medical assistance.
Can maybe Mr. Rankin respond, because this was discussed a lot before, so that he can explain to you what...
Well, this was verbiage that he just used in...
No, I know, but why it's not in the draft. Yeah. Maybe he can explain to you so that before you propose the sub-amendment.
And I appreciate that. I've been persuaded by officials that in a criminal code amendment, the words directly or indirectly would be too vague to be accepted. And as a result of that advice, we've taken out those words. But I meant to say in providing the reason for this, that it would affect people who, of course, provide it and those assisting in it. And assisting covers a wide array of activity. So that was the reason why those words couldn't be inserted on the basis of legal advice.
Would this also then cover a situation where there are referrals?
Wasn't intended to.
But nothing within, as we know, nothing within the Act requires a referral. There's no section of the Act that requires a referral. This Act is a criminal code, so all that we're clarifying is that there's nothing within this Act that compels an individual to provide or assist. But again, we all discussed the words directly or indirectly, and based on the officials' recommendations, that's why they're not there. You can propose. It's receivable. You can propose it.
Okay, I will. Thank you.
So there's a sub-amendment by Mr. Falk to add the words. Can you just tell me where you'd like to add?
Yeah, right after assist, to insert the words either directly or indirectly in providing medical assistance.
Okay. So right now there's what's on the floor is the sub-amendment only whether or not the words either directly or indirectly are added after the word assist. Mr. Fraser?
Thank you. While I appreciate the point, I don't think it adds anything. I think it creates uncertainty in the law. We heard from the department, directly or indirectly causes a problem for this being an amendment to the criminal code. The word to provide or assist, the word assist is very clear that it's covering more people than just those actually providing the medical assistance in dying. I think it covers what we're trying to do. I think indirectly or directly would cause a problem for us, and I wouldn't support the sub-amendment.
Any further debate on the sub-amendment? If not, Mr. Falk, do you want to close?
No, I think I've made my point. I think it's important that it's there, but I also hear what my colleagues are saying here, and the opinion of the justice officials, although I will support it anyway.
Perfect. So we'll move to a vote on Mr. Fox's sub-amendment, adding the words either directly or indirectly. Those in favor? And those opposed? Defeated. Now we're back on the principal amendment from Mr. Rankin, which we'll call NDP 4.1. Any further discussion on that? And if not, I'll go back to Mr. Rankin to close.
No, I think this adds a lot of comfort to a lot of people based on the testimony we've heard, and I hope it's accepted by the committee.
Thank you very much. So we're going to call the vote on the actual amendment. All those in favor? Unanimously adopted. Well done. So that means, Mr. Falk, 24.1 I think is also tied to the medical practitioner and the nurse practitioner. So that's dropped.
Skip 24.
Did I miss 24? I'm sorry. Let me go back. Oh. All right. So we're going to go to 24. Line 35 on page 7. Let me just go back to that. I'm sorry. So Mr. Genis has CPC 24 that I skipped over because Mr. Cooper's was tied to this, I jumped to that. So let's go back to CPC 24. Mr. Falk, will you put that forward so Mr. Genis can speak to it? Mr. Genis.
Thank you, Mr. Chair. This touches on some similar issues that were just discussed, but I think it includes some important elements. I want to say that the previous amendment does not provide conscience protection. It recognizes that the federal legislation on its own does not compel an individual to provide or assisted suicide or euthanasia. But it, in conjunction with existing policies, especially college policies in the province of Ontario, would infringe on conscience. So there is no solution of the conscience question by this amendment. I think it's a good amendment, but it does not fundamentally address the underlying problem. So my amendment, it clarifies that every person is entitled to refuse to receive medical assistance in dying. I don't think that point is particularly controversial. But to provide or refer for medical assistance in dying. So it actually provides a robust conscience protection for individuals. It does not mention institutions, but it actually provides that protection of conscience, which the previous amendment does not. And it specifically clarifies that referral constitutes involvement. And this is an important point, perhaps sometimes disputed. But if a country does not have capital punishment, they would almost certainly not extradite for capital punishment, because to directly refer or send someone to a place where they are receiving something that someone regards as unethical is a form of complicity. And in the medical context, referral is not providing directions. It's not letting someone know that a service is available. It's not providing for an early transfer of medical records. These things all need to happen and should happen. What referral is it's a direct recommendation of an individual to someone else for a service that an individual recommends they receive but is not qualified for whatever reason to provide themselves. So in the context of conscience objection, referral is not a solution. Referral requires an individual to be complicit in the action. And I think if you think of that via the extradition analogy, it's particularly clear. So this provides conscience protection. I think there seems to be some consensus that needs to be provided, and it clearly delineates the inclusion of referral as well in terms of conscience protection. So on that basis, I think it needs to be passed.
Thank you very much. Debate, Mr. Biddle.
Thank you so much, Mr. Chair. On the issue of referral, this is something that should be left to the colleges, to the provinces, something that needs to be regulated. I know as a lawyer, if there is an issue that comes before me in my firm, something that I object to on any level, I can refuse to take that client. But it's my job to refer an individual to a next step, but that's something that's done through a self-regulating body, the Law Society of Upper Canada, which is through legislation through the provinces. But I would like to get the department's analysis on this section, please.
Thank you. In this regard, just for my own personal satisfaction, I'd like to say I'm conveying advice from colleagues at the Department of Justice, because I'm a little outside of my domain of expertise. But the view of the department is that this would be outside the scope of Parliament's jurisdiction, that the provinces are the ones that have the competence jurisdictionally to legislate on this, and that likely it would be invalid federal law.
Okay, further debate? Mr. McKinnon?
Yes, I'd just like to point out, I guess, once again, that Part A of this amendment is already hardwired into our safeguards. In order to receive medical assistance in dying, an individual has to first request it. They can't be compelled to do that. And they have a explicit entitlement to be asked to confirm that before medical assistance in dying is rendered. So I don't see that A provides any useful capability, any useful protection, and of course B, as we have heard, is probably outside of our jurisdiction. So I shall vote against this.
Mr. Nicholson?
Thank you very much, Mr. Chairman. Going back to the example of the legal advice, if you don't want to provide legal advice or take on a client, Mr. Biddle, you indicated that within the legal profession we can and should refer them to somebody else. But I mean, this is something very different here. These are people who have conscious objections to what is going on, and we've already included directly or indirectly a person's ability on the grounds of conscience not to have to participate in this. And I think it's only reasonable to say, and I think it's a reasonable expansion of that, to say that you're not under an obligation to have to refer somebody to somebody who's going to do that for them. I think that if on conscientious grounds the individual does not want to get involved with this, they don't have to then go the next step of getting them to the kind of assistance that they're looking for. So I think this is just a reasonable expansion of what's already part of this.
Thank you very much. Mr. Biddle, you want to respond?
I see where this amendment's coming from, and I appreciate this, but I think this is a solution without a problem. We asked individuals and asked witnesses and heard evidence of the fact that there is no issue amongst the colleges and the associations with respect to physicians exercising conscience rights across the province, and there's nothing in this bill that requires an individual to do something. So I believe this is outside the scope. I don't think it's an appropriate time for the federal government to be legislating the affairs of the colleges of physicians and surgeons across the country. So thank you.
So maybe we'll go back to Mr. Genis to wrap up the arguments on this one. Mr. Genis?
3 quick points. The claim that this is a solution in search of a problem. Dr. Nancy Naylor in Strathroy, Ontario, has spoken out about the fact that she is leaving her palliative care practice because of the effect of the Ontario College of Physicians and Surgeons policy with respect to referral and this legislation. I doubt there are that many palliative care physicians in Strathroy, Ontario. So those who are concerned about access should take the opportunity to solve that problem very simply, seriously enough. In terms of the jurisdictional question, I would view this as an exception to an exemption in the criminal code. And it is legitimate for the federal government to put conditions on that exception. And just to respond to Mr. Biddle's comparison to lawyers, I think a better analogy is if someone comes to you in your law practice and says they want to commit tax fraud, and you say, if you were to say, well, I don't really do that, but I'll refer you to a lawyer who's willing to. I think that's a better analogy, because you'd be willing to refer someone to a service you can't provide, but I don't think you would refer someone to a service that you objected to ethically. That is the correct analogy, sir.
I just want to note before we vote, I want to explain why I'm allowing this amendment. Previously, I disallowed Mr. Beerson's because I thought it was undebatable that the subject of the amendment was completely outside the scope of federal powers. In this case, while I doubt that it's within the scope of federal powers. I do not dispute that there's a legitimate argument that it could be, and as a result, I'm allowing this to go forward in my usual practice of rathering the committee decide as opposed to just me. But I just wanted to explain that because I obviously somebody could consider there'd be contradiction that they said that this isn't within federal power and I'm still allowing it to go forward. So I just want to explain that. So now we'll move to a vote on CPC 24. All those in favor of CPC 24? All those opposed to CPC 24? Defeated 6-3. We will move to CPC 24.1 is dropped, but then we've moved to Lib 8 is dropped because NDP 4.1 was adopted. Then we have CPC 24.2, which I think is exactly the same on the medical practitioner. So we move then to CPC 25. Mr. Falk, will you put that forward for Mr. Kmiec?
Yeah, I will move. I don't think Mr. Kmiec is here, and Mr. Viersen will be speaking for him.
Mr. Viersen.
Thank you, Mr. Chair. This would amend the bill to read of an indictable offense and is liable to imprisonment for life without eligibility for parole until they have served 10 years of their sentence. This is a simple amendment for the simple reason willfully ignoring the law and killing someone without following the necessary precautions and guidelines is second-degree murder. We cannot allow gross negligence to go unpunished, and there must be sufficient deterrence to emphasize the importance of these guidelines. This is a human life we are dealing with, and it should not be trifled with. Thank you.
Thank you for your succinctness. Debate. Mr. Biddle?
I think this is excessive. This is creating a lesser offense. The offenses of murder, manslaughter still exist, and you're creating a imprisonment without life. I don't think it's appropriate in this particular case. I think the safeguards are there for a reason. I was just wondering if I can get the opinions of the department on this.
You chime in?
I think the idea behind this offense was to create, to give the possibility of a lesser offense being charged in cases where breach of the safeguards was perhaps not as serious as it might be in other cases. So it is true that the amendment would cause the penalty for this offense to match the penalty for murder. So in that sense, it wouldn't be a lesser offense. It would be an offense of the same seriousness as murder. One of the concerns that motivated the creation of this offense is that in jurisdictions that have these laws, breach of safeguards is sometimes detected, and yet there is very rarely any prosecution. And that might be, it's surmised, because the choice is either to prosecute for the offense of murder or to not prosecute at all. So the idea is to create a middle option so there can be a prosecution for an offense that more closely matches the wrongdoing. The other point I would make, just from a pure criminal law perspective, is that medical assistance in dying might be provided by way of medically assisted suicide, and that aiding a person to die by suicide is a less serious offense than murder. It carries a maximum punishment of 14 years and no minimum. So there might be a strange impact on a physician who had aided someone to die by suicide, where they could face a higher penalty for breach of the safeguards than they could if they had been prosecuted for the offense of aiding a person to die by suicide.
Thank you very much. Any further debate? If not, Mr. Viersen, I'll give it back to you to close.
Thank you, Mr. Chair. We are talking about the taking of life. That is the number one thing that we're dealing with this new bill. And I think that we need to ensure that we have consistency in ensuring that if you take a human life without the exemptions, that you pay, those that do the crime do the time, essentially. And that's probably the impetus for this amendment. So I would like to point out that in Belgium, they have significant stats of people who are being euthanized without explicit consent. They have statistics on this, so you'd think that it would be kind of a hidden thing, but no, they actually have stats on that. There's not the proper documentation being filled out and these kinds of things. So we do need to ensure that in Canada, no one is put to death without consenting to their death. One person that happens to is one too many. How many are we willing to be? How many are we okay with? That is the question. In Belgium last year, 1,000 people were put to death without explicit consent. So that we would, if that happens here in Canada, I would expect that there would be a similar sentence as if you were manslaughter or second-degree murder. So thank you.
So thank you very much. I just want to say that we had no testimony to the effect of 1,000 people in Belgium being put to death that way, and I just want to caution that I'm not sure that set is entirely accurate, but I understand the point you're making. You're trying to make the point that we should be very cautious.
Yes.
Got it. So now we will move to a vote on CPC 25 for Mr. Kamiksh. All those in favor of CPC 25? All those opposed? Unanimously defeated. Then we will move to PV 11. Ms. May.
Thank you, Mr. Chair. This is an amendment based on recommendations that the committee heard from a couple of witnesses from the Barreau de Quebec, as well as from Peter Hogg. Well, not from this committee. He testified at the Joint Committee back in January. Peter Hogg, of course, being one of Canada's leading constitutional law experts. The essence of this, and to save time, I won't read out all three clauses. You have them in front of you. But the essence of this is to ensure that there are provisions to allow equivalency in recognizing the federal law for medically assisted death with provincial laws. I'll just quote from Professor Hogg at this point, that he said, quote, "The advantage of doing that is that it would avoid overlapping legislation, and if you don't do something like that, issues of conflict between the federal and provincial law will be quite complicated, and they will be resolved by the rule of federal paramountcy, and that would be a bad situation. I think it can be resolved by a so-called equivalence provision." So that's what I've drafted based on many precedents in other federal laws where one can assess that the provincial law under consideration is sufficiently equivalent to what's being put in place federally that we'll avoid federal-provincial conflict of jurisdiction in this area. And I hope you'll consider it. Thank you.
Thank you very much. Debate? Mr. Biddle.
I was wondering if I could get analysis of this section from the department.
Okay, we have a few comments we can make for the committee's interest. Sorry, I'll move forward. First, it's not entirely clear how equivalency in effect would be assessed in this particular context. So if it was assessed, for instance, fairly liberally, so that, for instance, in Quebec, where it's not required that there be independent witnesses to the person's written request, and thus the Quebec law would, the federal criminal law would not apply in Quebec, then there might end up being a situation of differential standards and differential safeguards across the country. Another issue with respect to this is that it might be for the committee's consideration that the Minister of Justice would be better placed than the Minister of Health to determine when a provincial law is equivalent to the federal criminal code. And a technical issue with respect to the amendment that we've been informed of by our Legislative Council is that it doesn't entirely accomplish its intended effect. So it creates a power for the Governor and Council to order that provisions of the criminal law would not apply in a particular province, but it does not incorporate that notion into the exemptions themselves. The exemptions still require physicians and nurse practitioners to comply with Section 241.2 of the Criminal Code. So wording in the nature of or to comply with a provincial law that has been found to be equivalent would have to also be incorporated into the exemptions in order for the exemptions not to require compliance with the criminal law.
Thank you very much, Ms. May.
I appreciate always, as ever, the advice from officials. But given that Professor Peter Hogg is someone who wrote the book on constitutional law, literally, I mean, even when I was back at law school in 1980 at Dalhousie Law School, we were using Peter Hogg's text on issues of paramountcy and conflict of laws and federal provincial jurisdiction. The recommendation the Governor and Council may act, again, it's not a decision being made by the Minister of Health. Minister of Health is making a recommendation. The decision to accept a provincial set of laws as equivalent is one that would be made by Cabinet as a whole, obviously with the inclusion of advice from the Minister of Justice. The concern about how one would, in effect, determine its sufficient, whether it was sufficiently equivalent, is one that would engage the Cabinet as a whole and be based on the key sections of this Act that the officials are concerned about. So I think there are enough safeguards in this amendment as drafted to ensure that Cabinet will make a determination that's clear as to whether or not a provincial set of measures are sufficiently equivalent to allow the federal government in that province to allow, rather, the federal government's actions to exempt a province from the federal law if the provincial law is sufficient. And we certainly have many agreements of this type in other areas of law. I understand the criminal code is different. I accept that. But I think that the Governor and Council will be cautious in stepping back and allowing a provincial law to stand. And there would of necessity be, as there is in the case of the Fisheries Act or numerous other acts where the federal government determines that provincial legislation is sufficiently equivalent to step back, there would be a negotiated agreement between the two levels of government.
Thank you very much. I want to be as flexible as possible. My understanding is that there's a second issue with respect to the amendment, which is that we would also need to modify sections of 227 and 241 to then read that it would not be an offense to commit to do medical assistance in dying, provided that it was in accordance with this section or in accordance with the laws of the provinces or territories where Governor and Council. So my presumption is if we pass this, we would have to go back and just make sure that we did that. I want to allow you in principle to consider things so we can be flexible enough if we have to if it's adopted, to go back and find the right sections and do that. Any other debate? Not hearing. Do you want to finish on any principal point?
I think, Mr. Chair, that should this pass, I'm certainly open to finding other sections that need fixing, but let's not put the cart before an unlikely horse.
Fair enough. So we're going to move to the vote on PV 11. Those in favor? Those opposed? Defeated. We will then go to CPC 25.1, and let me just look at CPC because it's new. So let me just look at it. I mean, there's a. Mr. Vierson, I'm sorry that I keep having these issues with amendments only that you seem to put forward, but there's a real issue of receivability again on this amendment with respect to the scope and the intention of requiring a court of appeal to rule first. But just, again, to be flexible, why don't I let you at least argue your motion, and if you could try to explain to me why you believe it's receivable, I'll listen to you.
Thank you, Mr. Chair, for your graciousness. I guess it's probably part of the being new to hear that this whole inadmissibility thing is coming up more often. But I do thank you for your consideration regardless. This amendment came from, as I went through the bill, there seemed to be no way for an outside person to say, so this is to prevent doctor shopping, essentially. If we have someone who is depressed and wants to end their life, my concern is that a doctor who said, no, you're just depressed, we need to get you some help, that person can move away from that doctor, move to the next doctor and say, can you provide me with assisted suicide, find two other doctors, and that first doctor may be sitting there wringing his hands going, this person's just depressed, we need to give them help. This would give him, that first doctor, the ability to put a stop to that particular case and say, hey, I don't think we're looking at all the information. Can we go before a judge and see if this is where I can present, perhaps in a different setting, essentially, and that's where this comes out of. Again, if we lose one life without consent, that's what I'm trying to go after. So.
And I certainly understand substantively the principle you're trying to raise. I'm still forced to rule that this is beyond the scope of the bill and is thus not receivable, despite how flexible I really want to be, and I'm always erring on the side of there's no doubt in my mind that this is not receivable. So I'm sorry, Mr. Gersten. The next time, if you want some help, I'll be happy to try to work with you on some of them before.
Well, the timing was very rushed. It was. Like,
I totally understand.
It was like Wednesday evening. They said, yeah, by 5 o'clock tomorrow, you have to have amendments.
I totally understand.
So
I totally understand. So at this point, we have gone through all of the amendments on Clause 3. So now we would have a vote on Clause 3 as amended. So meaning all of the amendments that we've adopted so far in Clause 3 would be incorporated as a part of the Clause 3, and we would now have a vote on Clause 3 as a whole, including the amendments that we adopted. Is everybody good with moving forward to that? Is there any debate on Clause 3 as amended? Not hearing any. Not hearing any. We're going to move to the vote. All those in favor of Clause 3 as amended? All those opposed? So carried 5-4. And we now move to Clause 4.
Mr. Chair, I'm wondering if it wouldn't be a good time, now that we're moving on to a different clause, to maybe just take a 5-minute break?
Absolutely. Would that be okay with everyone? We'll take a 5-minute health break. So meeting suspended for 5 minutes. On va recommencer. Et,
We'll resume our sitting. We'll now turn to clause number 4.
I do that. Kind of like it. So we're now moving to CPC 26 in clause 4. However, this is one of the ones tied to the whole licensee scheme that was already ruled unreceivable. So CPC 26 is part of that whole process and is not receivable. Which brings us to CPC 26.1. So Mr. Falk, is this one of the ones again with the nurse practitioner?
Yes.
So this one we'll skip over?
Yes. Unless you'd like me to explain why.
Well, if you feel that you want to repeat the same thing again, more than welcome. But I think we can all deem we heard it and we appreciated it very much.
Okay.
If I may, I would really like to hear it again.
That's okay. We'll move on. I want to make sure we get through our agenda.
But I do want to say you were incredibly eloquent when you presented it this morning. So you're very welcome. So 26.2. I think this is not related to that. So this is over to you, Mr. Falk.
Thank you very much, Mr. Chair. It's a very simple change. It's changing the word may to shall, and we're asking the minister, or we're more than suggesting, we're insisting that the Minister of Health shall make regulations corresponding to this bill. I don't know if it needs more explanation than that.
Clear. That's good. Mr. Fraser.
Yeah, I have a concern regarding this, regarding the discretionary ability of the minister, and I'd like to hear the department or the officials comment on the change from shall to, or may to shall.
Thank you. It's not, what we're told is that the use of the mandatory type of language is not typical for regulation making powers. Other concerns with respect to that kind of language relate to what mechanism for enforceability would there, for instance, if those regulations were not made? Within what period of time must they be made? So it's all those questions surrounding how would you enforce a failure on the part of the minister to undertake these obligations when the language becomes mandatory. There's no mechanism proposed for the timelines and enforceability, which is why they tend to be expressed in the permissive rather than the mandatory.
Mr. Fraser?
Yeah, just on that, I agree with that sense that this should be permissive language in order not to take away the discretion of the minister to make whatever regulations the minister deems fit and ensure that the permissibility is there for regulations to be made on these various matters. But I would tend to agree with the analysis of the department then, and also note that it seems irregular that this would be anything but permissible language, and I therefore would not support the amendment.
Back to Mr. Falk and then Mr. Rankin.
Would changing the word shall to should, would that find more traction with the Justice Department, or is that also problematic?
The department.
It's my understanding that may is the standard formulation.
I'm going to then go to Mr. Rankin, who asked to intervene, and come back.
If any examples come to mind where it's not permissive, in other words, where the word may is not used in regulation-making powers, I can't think of any.
Unfortunately, this is where you hit one of the boundaries of my personal knowledge. When we receive these motions, we do quite a lot of consulting within the department to get the views of the experts. So, unfortunately, I don't know of any, but I wouldn't necessarily.
Mr. McKinnon.
I have gone through the same journey as Mr. Falk has, being also a non-lawyer. And I've come to understand this is our opportunity to extend a role of a discretionary power over aspects of the criminal code to the health minister. So we're basically offering to the health minister the ability to make such regulations as he or she seems fit to do.
Thank you. Any further discussion? Mr. Falk, do you want to close?
Yeah, notwithstanding what I heard from the justice officials, I think it would still be a good idea to give direction to the minister that, when you look at the content and the subject matter of the bill, it should be incumbent on somebody to make regulations. And the word may gives a person discretion not to do it, quite frankly. And, maybe at the end of the day that satisfies our needs here better if there are no regulations made and the thing just falls away.
Okay, so we'll move to the vote now on CPC 26.2. All those in favor? All those opposed? Defeated. We will now move to CPC 26.3. Withdrawn? Okay. So then we will move to Liberal 9. Mr. Fraser?
Thank you very much, Mr. Chair. This is, I'll just take a moment to get here. This is on the same Clause 3 under regulations, or Section 241.31, sub 3. And what I'm proposing is actually to change the wording that I had in Liberal 9 so that we would do the following, and that would be to add 3A, small Roman numeral 4. So at line, I believe it'd be 28, and add the following. Collection of information from coroners and medical examiners. And this would, adding this at number small Roman numeral 4 would allow and ensure that all coroners and medical examiners are included rather than the language that I previously submitted, which is a class of comprised of coroners and medical examiners. And we heard testimony to the effect that they should be added in order for the health minister to have the ability to make regulations in regards to working collaboratively with the provinces and then ensure that the information relating to coroners or medical examiners, the terminology differs between the various jurisdictions, in order to ensure that that information is subject to the health minister's proper regulation. So I would propose that amendment in that fashion, which is slightly different than the Liberal 9 that I had submitted.
So basically, as I understand it, the proposal is to add, after line 28 on page 9, the following, Roman numeral 4, collection of information from coroners and medical examiners. Thank you. Debate. Not seeing any debate. Mr. Fraser, back to you.
I have nothing further to add.
Okay. So we're going to proceed to a vote on Liberal 9. Welcome, Mr. Ouellette. All those in favor of Liberal 9? Any opposed? Unanimously carried. Next, we're going to... Bloc Québécois 9, I understand, was withdrawn? Yeah? Yes. Okay. So Bloc Québécois 9 is withdrawn, which brings us to CPC 27. Mr. Genest. And actually, CPC 27 is very similar to Lib 10. So Lib 10 cannot be put forward to CPC 27 works. I hope the two of you have worked together perhaps on a wording. Excellent. I'm very happy for that collaboration. Mr. Genest. Mr. Mafok, you'll move this so Mr. Genest can put it forward?
Yeah, okay.
Thank you.
Sure. Thank you, Mr. Chair. On this, admittedly relatively small point, we are trying to bring Sunny Ways back. But the version I'm going to move is an altered version. It's been provided to the clerk. Maybe I should just read it out for the benefit of those who may not have it in front of them. The Minister of Health, in cooperation with representatives of the provincial governments responsible for health, may establish guidelines on the information to be included on death certificates in cases where medical assistance in dying has been provided, which may include the manner in which to clearly identify medical assistance in dying as the primary cause of death, as well as the illness, disease, or disability that prompted the request for medical assistance in dying. So by replacing the must with the may and the R2 and with may later on, it addresses the jurisdictional concern. It doesn't create an obligation on the minister, but I think the minister would be wise to bring in these these guidelines, especially based on the evidence we heard about some very serious concerns from the perspective of those who fill these documents out in the various provinces, in terms of conflicting guidelines from their professional bodies and potentially from legislation. So I think there's consensus here, and there we go.
Very much, Ms. Khalid. Do you want to speak to that?
Yes, thank you very much, Mr. Chair, and thank you, Mr. Genis, for the opportunity to collaborate with the other side. So yes, I had proposed Lib 10, which basically speaks to that, and I think that the reasons for it are to have sound data that really informs our decisions going forward with respect to what this bill is going to entail and how it will affect Canadians. I think it's a great step forward, and I completely agree with Mr. Garnett's amended CPC 27, and I will be supporting it. Thank you.
Excellent. Any further debate? Mr. Biddle, then Mr. Fraser, and we'll keep going. Mr. Biddle.
I was wondering if we could hear from the department on this language.
Yes, so again, I'm passing on information from some of my colleagues who are more expert in these areas. The Minister of Health already has the ability, without this amendment, to sit down and work with the provinces to establish guidelines on a cooperative basis. And of course, nothing that Parliament could do could compel the provinces to make these changes, which are in their area of jurisdiction.
Sure.
Thank you, and I appreciate the amendment, and we'll be supporting it. I think it does respond to a very important matter that was brought forward by witnesses of our committee in hearing that there definitely are issues with regard to the cause of death being stated on death certificates, and I believe this adequately responds to that. And while it is permissive and obviously will result in collaboration between the provinces and territories and federal government, I believe this gives some direction in that regard, but it responds ultimately to that issue that we heard, and I therefore think it's a reasonable amendment. Thank you.
Excellent. Mr. Rankin.
Chair, I'm concerned about the amendment for the reason that it may be semantic, but identifying at the end of it, identifying medical assistance in dying as the primary cause of death, as well as the illness, etc., that prompted the request for medical assistance in dying. As I see it, the cancer, let's say, is the condition that causes it, and the medical assistance in dying is the manner in which it occurred. Otherwise, I'm concerned that there's we'll witness a sudden drop in deaths caused by cancer, ALS, etc. So that specification, if I'm understanding it properly, causes me great concern, and unless that's clarified, I won't be able to support this.
I think we can maybe clarify. Mr. Genis, Ms. Khalid, do you have a proposal? Perhaps we can say include clearly identify medical assistance in dying as the manner of death, as opposed to the primary cause. And that way, I think Mr. Rankin might be able to support it.
That's correct.
Yeah, I mean, look, I mean, I think in a very technical sense, not even in a very technical sense, actually. I mean, assisted dying it's hard to dispute that if someone takes pills, receives the injection, that is the cause of death. And the objective of this amendment is to seek to ensure that there is alignment between the sort of professional obligations of those who are filling out these death certificates and the legislative framework around medical assistance in dying, so-called. The issue of sort of possibly a sudden drop in reported deaths around cancer, ALS, that's why I think it's very important to identify as well, in some manner, the illness that prompted the person to seek euthanasia or assisted suicide. So I mean, I'm comfortable with the language as it is, and hopefully Mr. Rankin will consider those arguments in his business vote.
One other point that I didn't raise is whether or not there could be implications for people seeking life insurance coverage as a consequence of this. We were told very clearly in committee that, and there's been newspaper articles and other media, to the effect that the life insurance people will cover people if the underlying cause, the primary cause is cancer, ALS, etc. But if medical aid in dying is provided, then they will still cover the individual. I fear that this could have an unintended consequence the way it's worded.
I again suggest somebody may want to sub-amend, use the word manner, but yeah.
I'll just say on that, I mean, what the insurance provisions and how they apply is a separate issue.
Yeah, I understand. I understand, and I appreciate that, and I get that. But you have an opportunity, I think, to have relatively unanimous consent to your motion if you make a wording change, and otherwise you're going to have a constant debate and not have unanimous consent. So there's, in the collaborative process that I think we've been working on, my suggestion is somebody sub-amend it to put the word manner there, and if you're not going to change the wording, and we'll have a debate on that.
So are you asking me? I mean, I'm comfortable with the language as is, but of course, Mr. Rankin's welcome to propose a sub-amendment, and then the committee can move forward in that.
Ms. Khalid?
I am happy to propose that sub-amendment, changing primary cause to manner of death, as well as the illness, disease, or disability that prompted the request for medical assistance in dying. I think that Mr. Rankin raises a good point, and I'm happy to work in collaboration.
Thank you. So now that the sub-amendment, the debate is on the sub-amendment to change the word primary cause of death to manner of death. Any debate? Mr. Fraser.
On the sub-amendment, I don't believe that has any effect on what we were trying to accomplish with this amendment as it was presented, and would address the concern of the individuals we heard from as witnesses who had a concern regarding what is placed on the death certificate. So I have no difficulty at all in supporting the sub-amendment to change the wording to manner. I think that's appropriate.
Thank you. Any further discussion? All those in favor of the sub-amendment? Unanimously adopted. Now we go back to the principle. Any further debate on the principle amendment? Mr. McKinnon.
Now that we have this sub-amendment, we have kind of convoluted language, I think. The manner in which to clearly identify the manner of death seems a little circular, I guess. I wonder if we could have another sub-amendment to get rid of the manner in which, so we could say in cases where medical, which may specify or may identify medical assistance in dying as the manner of death.
That's what it would now say.
Well, no, it says the manner in which to clearly specify.
Oh, so.
I mean, I can't propose sub-amendments, of course, but we could, just for linguistic purposes, replace the first manner with way, which wouldn't change the meaning and would read better.
Yep.
You would just delete the words which are to include the manner in which to. So provided and then straight to clearly.
That amendment.
Okay, so
before that happens, maybe we can replicate our success from earlier and take 2 minutes and
I think that would be great.
And rather than going back and forth sub-amendment after sub-amendment, and if it's all right with everyone.
Do you guys want to walk over and just see how you can clarify with Mr. Rankin included, so the three of you can do that? We'll take a 1 minute break. I think it should take about 1 minute.
After.
I didn't understand that. And again on reads. Ms. Khalid?
Thank you. So starting from the top, because just for clarity's sake, the Minister of Health, in cooperation with representatives of the provincial governments responsible for health, may establish guidelines on the information to be included on death certificates in cases where medical assistance in dying has been provided, which include the way in which to clearly identify medical assistance in dying as the manner of death, as well as the illness, disease, or disability that prompted the request for medical assistance in dying.
Basically, we're changing the word manner to way.
Yes.
Okay, fine. So that's a sub-amendment?
Hold on. I think Mr. Jennings wants to...
Just a small point of clarification, Ms. Cully, when you read it out, I don't think you said the word may before the word include in line 9. So I just want to make sure you're not meaning to remove that. It's supposed to say.
But the only change we're now making, because that was already there, is changing the word manner in line 1, 2, 3, 4, 5, 6, 7, 8, 9 to way.
Right.
So that's a sub-amendment you're putting forward, Ms. Khalid?
Yes, sir.
Excellent. Any discussion on the sub-amendment? Let's vote on the sub-amendment. All in favor of the sub-amendment? Unanimously adopted. Now we come back to the principal motion as amended by both sub-amendments. Any further discussion on the principal motion? Not hearing any. Let's vote on the principal motion on CPC 27 as amended. All those in favor? Unanimously adopted. Excellent. Good collaborative job. So Liberal 10 is combined now with CPC 27, so that goes away. CPC 27.1 is withdrawn. So now we move to a vote on Clause 4. So now we'll be voting on Clause 4 as amended. Is there any debate on Clause 4 itself to anyone on the whole? Not hearing any, I'm going to put Clause 4 as amended to a vote. All those in favor of Clause 4 as amended? Unanimously adopted. Well done, everyone. Now we move to, sorry. Clause 5? Sorry. Well, then we'll do that. Nobody amended Clause 5, so let's go to Clause 5. Everybody take a quick look at Clause 5. Which is on page 10. Is there any debate on the on clause number 5? I'll give everybody a few minutes, 30 seconds to read it properly. Thank you.
Mr. Chair.
Yes,
Just,
Mr.
if I could just ask the department for their input on this section, and if they have any thoughts on its effect, and
I'd be happy to briefly explain it to the committee. Yeah. So
that's the right word.
You will recall that in section 241.4. Sub 2 is a new offense for destruction of documents related to medical assistance in dying with a specific mental intent to do a couple of things, either intent to impede someone's access and so on. This would amend that offense once the monitoring regime comes into force. It would add the specific intent of someone who destroys a document with intent to interfere with someone's compliance with their monitoring obligations. The rules related to monitoring are set to come into force on a date to be determined by order in council, unlike the rest of the legislation which comes into force on royal assent, to allow time for the Minister of Health to develop the regulations. So this one would only come into force when the regulations are ready, because only when the regulations are ready will physicians and nurse practitioners have the obligation to report. So interference with their obligation would be an amendment made to this offense when those other provisions come into force. It's definitely complex.
Perfect. well, all of the members of this committee can clearly understand complex issues, so everybody's grasped that, I'm sure. Any debate on clause number 5? Not hearing any. We'll move to a vote on clause number 5. All those in favor of clause number 5? Unanimously adopted. So now we move to clause number 6. Clause number 6 is first amended by, CPC 28 is not receivable. Again, it's the licensee thing that we've ruled out of order from the beginning. CPC 28.1 is, again, the nurse practitioner, so it's withdrawn. 28.2 withdrawn, 28.3 withdrawn. Okay. Which would mean that clause 6 then has really no amendments for us to consider. And we can move to a debate on clause 6 itself in the original form. So everybody take 1 second and please read clause 6, and I'll give everyone 30 seconds to read clause 6. Mr. Rankin.
I'm in favor of it. I just wanted to ask the officials if there's any problem with the fact that in some places we're using the word individual and in other places we're using, as we do in 2 sub B of the exemption, a person. Does that cause any difficulty from a drafting perspective? We used individual, you recall, a moment ago on the greater certainty clause as an example.
Ms. Kleinberg?
It creates a funny situation where sometimes person in the criminal code means both an individual and also a corporate entity or another type of organization. In other circumstances, because of the context, it's likely to be restricted to something a human being is actually physically able to do. The standard formulation for offenses and exemptions is always framed in terms of any person. So this is absolutely consistent with the way the criminal law is drafted.
Mr. Fraser.
Just on that point, I think it is an excellent point. I want to try to be consistent in the wording. I mean, I would imagine this obviously means an individual as well. That would be identical. Would there be any problem with amending the wording so it's consistent and say an individual throughout?
Yes, there would be a coherence with the entirety of the criminal code problem with that. We just don't use individual unless there's a very specific context where we're absolutely certain we mean only to catch human beings as opposed to corporate entities. Otherwise, corporate bodies and organizations are able to commit criminal offenses and be prosecuted for criminal offenses. It very much depends on the context, whether it's an offense that an entity is able to commit, but there's no problem with the use of drafting in terms of a person.
Do you know of other examples of sections within the criminal code that would both interchange between an individual and a person?
I can't think of any off the top of my head where we use individual.
Okay, thank you.
Any further discussion? Mr. McKinnon.
Yes, I'd just like to ask officials, I'm not quite clear in the context. Did this exist? I wonder if you could clarify that for me.
So Section 245 is the offense of administering a noxious substance to a person. In the Carter ruling, the Supreme Court did not identify this offense as being core to the prohibition against physician-assisted suicide. So this offense has not been struck down. It is an offense that is extremely unlikely to ever be charged in the context of medical assistance in dying. Nonetheless, we considered that out of an abundance of caution, because technically it might be an offense that could be legally applicable in the context of medical assistance in dying, that the exemptions, a basic set of exemptions were put in to give certainty that also this offense should not be charged where a person has engaged in medical assistance in dying in conformity with the rules. But it's extremely unlikely that this is an offense that would ever be a live issue in such a case.
Thank you. Any further discussion on clause 6 was about to say Section 6. Mr. Falk.
Just a question for the officials. What you're saying is that subsection, or the clause 6 that we're looking at right now, subsection 245, is actually outside of the Carter ruling?
Yes, the offense has not been found to be unconstitutional, but nonetheless, the offense of administering a noxious substance to a person is, in law, potentially an offense that could be charged where a physician or nurse practitioner administers a substance to a person within the meaning of medical assistance in dying. So because it's an offense that could technically be committed in law when a physician engages in medical assistance in dying, the exemptions were put in this offense as well, just to ensure that there was not some we went through the criminal code to ensure there weren't other offenses that might be committed for which the exemptions also had to be made available. So, and this was the one that we identified.
Any just further comments or questions, Mr. Falk?
No.
No? Okay. No, any further debate?
I'm sorry. That it would seem to me that this provision makes sense, that it would have to be there because that offense would be necessarily incidental in carrying out the medical assistance in dying. So therefore, I think that this is a good measure, obviously, to have in here.
Understood. Any further debate? Not hearing any, we're going to move to a vote on clause number 6 as drafted in the legislation. All those in favor of clause number 6? All those opposed? Carried. I think, Mr. Nicholson, do you vote in favor or are you abstaining?
I abstained.
Abstained. So carried. Next, we move to clause number 7. Clause number 7, the first CPC 20, I think this is incidental, right? It's
to CPC 1 and 4.
So my ruling on CPC 29 is it's incidental to C1 and C4 that were ruled unreceivable. And as a result, CPC 29 cannot go forward because it would have presumed that we have done something that we have not done in the other two amendments. But fortunately, I don't have to see Mr. Viersen's disappointment when I tell him that, since he's not in the room. CPC 20. Right now the bells are going for the vote. I've been advised by a couple of members that they have agreed to meet in the lobby a little early. So can I suggest we do 29.1 and then go to the vote, and then we'll come back? Is that okay? I need unanimous consent to carry on once the bells start ringing. Do I have unanimous consent of the committee members to do that?
We do 29.1.
Sorry? Yeah.
No.
No?
No.
Okay. Then we will we reconvene after the vote. Je peux demander à tout le monde de siéger. And we're going to continue on our clause-by-clause review. We have agreement amongst the different parties that what we'll do is we will go through to Clause 11. We will finish with Clause 11, and then we'll break and come back at 4 o'clock tomorrow to do the preamble. And we'll be working collaboratively on different parts of the preamble that we all want to make sure are properly reflected, hopefully unanimous agreement for tomorrow. And then I believe we'll be finished in about an hour tomorrow is my guess, provided that people provide things that are receivable or collaboratively agreed. So we'll move now to where we were. Clause 7, Section 29.1 is an amendment from Mr. Genis. Mr. Falk, will you move it to put it on the floor for Mr. Genis?
Yes.
Thank you. Mr. Genis, the floor is yours, sir.
Thank you, Mr. Chair. So this amendment makes what I think is a language consistency fix. The clause presently refers to assistance that a person was entitled to receive. Now that is not language that is used elsewhere in the bill. So I've changed it to for which they were determined to be able to receive that assistance. So it doesn't use language which is not consistent with language used elsewhere. Now I did change illness, disease, or disability to illness or disease because I don't think disability is reasonably covered in the language used in other parts of the bill. But of course, if people like the second part of the change and don't like the removal of disability, then you're of course welcome to move a sub-amendment which would change the one point but not the other.
Thank you very much, Mr. Genis, for your motion. Mr. Hussain.
I'd like to thank you, Mr. Chair. I'd like to get the Department of Justice officials' take on the consequence of this amendment.
Yes. So unfortunately, I can only speak very generally to this clause because this the lead for this particular legislation and amendment belongs with another department, and they worked with a different set of drafters, so I was not present in the drafting room. I would think the best word, if the committee is looking to change the word entitled, I would think the best word might be eligible, because that would match up with the eligibility criteria. But I'm not really comfortable making too many comments just because this is a statute under the responsibility of a different department and minister.
If the desire is to, if members agree, I would be quite comfortable with the use of eligible instead of the word able, if that is what people want. It seems clear to me.
We can then deem, if you want, that it was moved with the word eligible so that we don't have to start dealing with a sub-amendment and just say it was moved with the word eligible. Mr. Fraser.
Thank you. My reading on this is that the entitlement or the eligibility is with regard to the medical assistance in dying and not the pension scheme itself. Yes. Is that the reading of the department? I think that's obvious, but I just want to be absolutely sure. Is that your reading?
That would be my reading as well.
Okay. That being the case, I would support the sub-amendment to...
Or the amendment.
The amendment, okay.
Because
so
he's going to move the amendment using the word eligible.
Right. So I would support that use of the word eligible. I believe, though, I would take Mr. Genis up on his comment that he would be okay with adding the word disability if it was required in the first part to get support. I do think it's important to maintain consistency throughout the bill, and so I would look to insert the word or disability there. But with the word eligible, I think it would be an amendment I could support.
Okay, so there's a sub-amendment to, I'm assuming you're not just in agreement to make it as if you moved it that way?
I would like to move it the way I moved it in that way, but I think, a sub-amendment is a... Okay.
To add the word disability. So right now the vote is to add the word illness or disease or illness, disease, or disability as it's going back to the way it was drafted before on that part, those three words, illness, disease, or disability. So we're adding back the word disability, and we're putting a comma between illness and disease and an or between disease and disability. Correct, Mr. Fraser?
Correct.
Is there any discussion on the sub-amendment? Not hearing any. Can I have a vote on the sub-amendment, which again is only changing illness or disease to be illness, disease, or disability? All those in favor? Any opposed? Carried. Now we're back to the main motion as amended. So basically, it's deemed to have died as a result of the illness, disease, or disability for which they were determined to be eligible. Any further discussion on the motion? Mr. Genis, do you feel you have anything more to add? Okay, so we'll move to the vote on CPC 29.1 as amended. All those in favor? All those opposed? Abstain? So carried. So 29.1 is carried. We then move to, I think this is the end of Clause 7? Yep. So we get to vote now on Lucky Clause 7. So this is going to be Clause 7 as amended. Is there any discussion on Clause 7? If not, I will take a vote on Clause 7. All those in favor of Clause 7 as amended? Any opposed? Carried unanimously. We now move to Clause number 8. Clause number 8. I believe Clause number 8 from CPC 30 is related to other amendments, Mr. Vierson, that you introduced that were back to CPC 1 on the terminology, and as a result is inadmissible. So we're going to bypass CPC 30, which is inadmissible, and the same. Yeah, well, Clause 8, we'll get to a vote. Yes. So now I'd ask everybody to just look in their bill and look at Clause 8 again, and I'll give everyone 30 seconds to refresh their recollection as to Clause 8. Is there any debate on Clause 8 as a whole? Mr. McKinnon.
I'd just like to ask officials to confirm that this is the same situation as previously regarding noxious substances.
No, well, it wouldn't be, but Ms. Kleinberg?
Yeah, no, this is an amendment to the Corrections and Conditional Release Act, which
basically that they don't have to go through a process when the person dies to do
an investigation that is otherwise required when an inmate dies in custody. This is an amendment that says that that investigation is not required when the person dies as a result of medical assistance in dying.
Thank you. I'm squared away now.
Thank you very much, Mr. McKinnon. Any further discussion on Clause number 8? So not hearing any, we'll move to a vote on Clause number 8. All those in favor of Clause number 8? Unanimously adopted. So now we move to Clause number 9. Clause number 9, CPC 31 is again connected to CPC 1. Sorry. But CPC 30, I'm sorry? Yes. CPC 31.1 is receivable, and Mr. Genis, in order to reflect the changes that were agreed to before, will now move it with the changes from before. So if you want to read, Mr. Genis, what you would now propose.
I only have one thought. Okay, so this is the same amendment, and I'm moving it in a way that reflects the sub-amendments that were made previously. So is deemed to have died as a result of the illness, disease, or disability for which they were determined to be eligible to receive that assistance in accordance with, etc. So I think basically substantively the same as the previous amendment.
All right. Deemed move. Any debate or discussion on that? Mr. Fraser?
Department officials to just to illuminate whether or not it would be considered the same as the previous one that we did?
Yes.
Okay, thank you.
That was a very easy answer. Any further discussion or debate? Since we already just passed it, I don't think we need that much debate. All those in favor of CPC 31.1? And those opposed? Abstain. So carried. Now we move to, let me just check, is there anything else? No, Clause 9, there's nothing left on Clause 9. Is that correct, Mr. Clerk? Perfect. So now we will move to Clause 9 as amended. I just ask everyone to just refresh your recollection to take the bill and reread Clause 9 as amended, and then we'll vote on Clause 9. So now that we've had a chance to look at Clause 9, is there any debate or discussion on Clause number 9 as amended? Not seeing any, we're going to proceed to a vote on Clause 9 as amended. All those in favor of Clause 9 as amended? Any opposed? One opposed. Carried. Next we move to Clause number 9.1. 9.1. Oh, here it is.
No, it's here.
Oh, sorry.
It's a new clause that Ms. May wants.
Sorry. Ms. May is proposing to insert a new clause 9.1, so we move actually to PV 12 at this point. So, Ms. May, would you take the floor on PV 12? And I would note that PV 12 and G3, which would come after PV 12 because PV 12 was inserted first. If PV 12 is adopted, there would be a problem with receiving G3. So, but the first one is PV 12. So, Ms. May.
Thank you, Mr. Chair. I did intend to canvass the subsequent amendment G3 as well as my amendment PV 12, because although the language is different in the first subsection, subclause 1, the intent and the effect are entirely identical between G3 and PV 12 in my first clause. The intent here in the first clause is to ensure that within 3 months of the coming into force of this bill, the Minister of Justice will initiate studies dealing with those areas that were canvassed and included in the recommendations that came from the all-party special House and Senate committee, the question of requests made by mature minors, the questions of whether a grievous and irremediable condition is a mental illness, and requests for basically advanced directives. That category, that cluster of issues were not included in this bill, but we've had indications might be included later. So the first part of my clause initiates studies in this area. Now, what's not in G3, and which I think is quite important, is my subclause 2 of PV 12, which, having initiated the studies, which would also be gone under the following Liberal amendment, but my subclause 2 ensures that there would be a public tabling of a report based on those studies. The timeline is generous, so 3 months after the coming into effect of this bill, after royal assent, the studies would be initiated by the Minister of Justice, and 2 years after royal assent, at the latest, they could come in earlier, but within 2 years there would be reports tabled in Parliament of any studies and recommendations from the studies. So that's a summary of what I'm proposing. Again, I've spoken to Ms. Khalid about it. We're absolutely certain that the first half of mine and all of the Liberal amendment are virtually the same. The big difference between mine and the subsequent amendment is to ensure that the studies that are initiated go someplace, and the place that they go is Parliament with a time limit.
Thank you very much, Ms. May. Debate. Ms. Khalid.
Thank you very much, Mr. Chair. I do appreciate the spirit in which Ms. May has presented this amendment, and I very much agree with the intent behind it. I think over the past couple of weeks, and quite in fact, the whole this whole experience with medical assistance in dying has has really shed light on how important such an issue is and how varied the opinions are on how this should become law and whose rights are to be included and how the process is to be administered. So I appreciate that such a study needs to be done. And that we really undertake a big review on how and what is the best way to do this. So I do appreciate that such a report or review should be initiated. However, having gone through the time constraints that we have with passing this bill and getting it through the House, etc., I also appreciate the time that is required to undergo such a review. And I don't think that it would be beneficial to tie the hands of the minister by setting a specific timeline. I think we should give this a wholesome review as it is, and so I will not be supporting the second clause of this bill. Amendment.
Thank you very much. Any further discussion on this, Mr. Warwa?
I would agree that I believe the Liberal motion that is going to be following is a better. The time frames are more realistic, and therefore would not support Ms. May's amendment.
Any further discussion? If not, I'll go back to Ms. May to close.
Yes. Well, thank you, Mr. Chair. Given that the second amendment comes from not just one Liberal member, but the Liberal caucus, and is now presented as a government amendment, I think we can assume it will pass. And I think it's unfortunate to initiate the studies without the request for tabling them back to Parliament afterwards. And I do think 2 years is generous. But if Ms. Khalid feels, or the Liberal caucus feels, that 2 years is too much of a rush, perhaps they'd like to offer a different time limitation. But it certainly is unfortunate to have studies initiated without a requirement that their studies themselves and their recommendations be made public.
Thank you very much. We'll now move to a vote on PV 12. All those in favor of PV 12? And all those opposed? Defeated. And then we will move to Liberal caucus, or G3. Ms. Khalid.
Thank you, Mr. Chair. As I indicated earlier, this amendment proposes to initiate a study. So I will just go ahead and read it. So the Minister of Justice, the Minister of Health must no later than 180 days, which I believe is 3 months. 6 months, sorry. After the day on which this Act receives royal assent, initiate one or more independent reviews of issues relating to requests made by mature minors for medical assistance in dying, to advanced requests, and to requests where mental illness is a sole underlying medical condition. I believe that these 3 issues were something that continued to come up as we listened to witness testimony, and I'm very appreciative of the Liberal caucus as a whole trying to find solutions for addressing the concerns that were raised by Canadians.
Thank you very much. Debate. Mr. Warwa.
Thank you, and I appreciate the amending motion. I believe at a 5-year review, which is what is in C14, would be a more appropriate time for us to review. The legislation has to be up and running for a reasonable length of time for us to be able to spot problems and changes that are necessary. If a standing committee of justice wants to, after a couple of years, say how's it going, and we want to discuss the issue of advanced directives, minors, that would be appropriate, but for it to be in the legislation, I think is presumptive, and I think be more appropriate to stick with C14 in the 5-year review.
Thank you very much. Further debate, Mr. Fraser.
Thank you very much. I support the amendment. I think it's reasonable based on the evidence that we heard from the witnesses regarding the concern that the 3 elements, mature minors, advanced requests, and requests for mental illness, those concerns were were addressed obviously in the special committee and the majority report and the minority report, well done. But we hadn't had a chance at this committee to really take a fulsome approach, and we need to undertake that so that we have broad consultation with Canadians. I think it's reasonable that after 6 months that study should begin. It doesn't say when necessarily there has to be an answer on that, but I think it's a reasonable way for us to study those answers without suggesting any outcome or prejudging any sort of outcome before hearing Canadians on all sides that we haven't had the opportunity to do given the time constraints we've been under to get this legislation in place. I think it's a reasonable measure and I support the amendment.
Thank you very much. Mr. Falk, then Mr. Rankin.
Yeah, Mr. Fraser, I appreciate your comments, although if we would consider all the witness testimony that we heard last week, there's a lot of things we would have done differently in this bill so far. And we could argue both sides of this particular amendment as well based on witness testimony. I would strongly support Mr. Warwa's comments that, we have a 5-year review coming. It's part of the legislation that the government has asked us to study here. And I think that review is a reasonable amount of time to see if there's any particular trends that are developing, if there's going to be any concerns with the bill that needs to be addressed. And I think that's the time when we should be studying to expand or contract the bill as it is today.
Thank you. Mr. Rankin.
I guess 2 points. The first is that under the terms of, to Mr. Falk, the review of the Act only allows, in its current wording, of course it could be amended, that the provisions enacted by this Act be referred for discussion within 5 years. So anything else, such as mature minors and the advance requests and mental illness, would not be part of that because just by the very wording of the section, they wouldn't be eligible. But the other question I had, and it's just a technical question, we don't define the term advance requests anywhere in the bill. Does that cause anybody any difficulty? We know, having looked at it for months, what we mean, but I'm not sure the average Canadian reading this would do so. So therefore, if this were to have any meaning, I would have thought we should provide a specific definition of that term.
I was just going to look at the preamble to see how it was referred to. It's in line 21 of the preamble, it refers as well to advance requests. That doesn't mean it's clear, but that's what it refers to.
Yeah, I had this amendment proposed as it is. I was going to make the same comment when we got to the preamble. I know what it means. We around here know what it means, but does anybody else?
Can I ask a question to the department? Again, I'm not sure as chair that's what I'm supposed to do, but I'm going to do it anyways. If the word advanced directives was replacing advanced requests, would that cause any issues for either the Department of Justice or Department of Health, provided it was consistent throughout the Act?
I would like our colleagues from Health Canada to comment, but my understanding of why we tend to use advance requests relates to the fact that it might be possible for, should it one day be something that Parliament decides to do, that it might be outside of the advanced directive regimes that the provinces have set up for other purposes, that it might be kind of a standalone regime. And also advanced directives, I don't think that's a common term used in all the jurisdictions across the country. So I think there was some desire to use slightly more general language so we weren't giving the sense that people were being boxed into the legislative advanced directive regimes under provincial governments.
That's exactly what Professor Downey said when she spoke on behalf of the Provincial Territorial Task Force for which she was the research director. That's exactly the point that she made.
Comfortable, Mr. Rankin?
No, I'm just making the same point. I mean, I don't know what an advance request is. I'm comfortable leaving it. It was to be just asked for clarification. It was only to say if you're comfortable that that term has meaning, it's not defined anywhere. It appears in a criminal code. It's a bit odd. I just put that out there.
Yeah, I mean, I just to go back, I would think that the Minister of Health and Minister of Justice would probably have a common understanding in the same sense that we would as to what this actually means in the context of the Act, but I'm obviously prepared to receive any sub-amendment that is proposed that would, substitute any other wording. And while you're thinking about that, Mr. Genis, you wanted to say something?
Yeah, I just wanted to say, and maybe ask the officials about this. When we discussed C14, which was the amendment about death certificates, the point was made that to have a must, a requirement of the minister in the criminal code was unusual and raised some issues. So we changed the wording in that case to may. This proposed amendment, on the other hand, does use a criminal code provision to instruct the justice minister. I wonder if you think, if in this case you would regard that as common or appropriate, and language like may would that be more appropriate in this case, given what we decided in the case of the other amendment?
That happens all the time. So the first thing I would note is the location of this clause in 9.1 is such that the text of this clause would not actually go into the criminal code. It's a part of the bill, but it's not an amendment to the criminal code to insert this into the criminal code. But in theory, yes, the must has the same challenges in the sense that what would be the mechanism for enforcing it if it didn't happen, and there's at least a timeline, so there's a period by which it has to happen. If it doesn't happen, though, the enforcement mechanism is still uncertain.
So I can't move sub-amendments, of course, but on the basis of clarity, I might suggest that a member of the committee make that change so that the public has sort of a clear understanding of what what the words actually mean in this context.
Oh, well, if a member chooses to do that, then a member may choose to do that. I'm going to look to the members. Mr. McKinnon.
What sub-amendment would you propose?
Must with may in line 2 of the amendment. I think that makes the same change we made in similar contexts elsewhere.
I don't have a problem with that amendment. I'm just not sure it does anything. I mean, the Minister of Health and Justice may do this anyways. We're not really extending them anything. I think what we're trying to do is make a recommendation to them. Is there some more common phraseology for making a recommendation that the Minister give us a report at some point in time? Anybody can answer?
I think again, right now I want to draw, again, Ms. Khalid had her hand up, and then I'm going to go to Mr. Warawa. Ms. Khalid?
Thank you. And just to clarify, I think the prior amendment that Mr. Guinness is referring to dealt with a bit of a provincial jurisdictional matter where we were talking about proposing regulations that may be more of a collaborative approach with respect to the provinces. I think this is a little bit different in that we are not talking about any jurisdictional issue with respect to provinces and are really enforcing within the department and within the ministries for such a report to take place.
Mr. Warawa?
I think the suggestion of changing the word must to may is a good one. It provides, as a part of the bill, C14, it provides clear direction to the Minister of Health and Justice, but it does not bind them, and it provides a suggested direction, gives them discretion. It gives them the discretion of who is the lead on this. It gives them discretion if 180 days is not a practical date, and maybe 270 days is a more practical. It gives them the discretion as there's consultations ongoing with the provinces and territories. It gives them discretion as what the independent review would look like, and I think it's a good suggestion to give them that latitude so that they're not bound. Otherwise, they're accountable, but with no clear consequence if they don't meet that. But it could be embarrassing to the government or the minister. So providing that discretion, I think, is a good idea, and would suggest maybe a sub-amendment of changing it from must to may. I'd like to move that.
Basically, Mr. Warawa has put forward a sub-amendment to change the must in line number 2 of the new section 9.1 to May. So now the debate is on the sub-amendment. Mr. Biddle.
Thank you, Mr. Chair. I appreciate Mr. Worrell's concern about embarrassment to the Minister of Health and Justice. And it touches my heart, but I think this is something that the ministers have committed to and something that we should go forward on, and I think it's something that they should be compelled to do, and it's to begin this. This isn't a complete report in 180 days. It requires them to begin. I think it's an excellent step, and it shows willingness to hear from concerns of Canadians, and that Canadians want to see action on this, and look forward to receiving that or seeing that report being initiated 180 days after the Act receives royal assent.
Mr. McKinnon, then Mr. Jenness. Sir?
I was just going to suggest that as a sub-amendment we use is requested to, but I don't really have a strong objection to keeping it the way it is or the amendment.
But it's also when a sub-amendment is on the floor, you can't suggest a sub-amendment to the sub-amendment, so it's out of order. You can't do that. You have to.
I'm not saying that. That's what I would have said if I said that.
Mr. Jenness, briefly, because again, we do have three members of the committee, and then Mr. Fraser.
I appreciate your indulgence. I just want to be clear that the point of me suggesting the sub-amendment was not to say that the minister should or shouldn't be compelled. The official's advice is pretty clear that through this section we cannot compel the ministers. So I think simply on the basis of the word must is misleading, not that it's substantively different, but it implies an obligation on the ministers that doesn't actually exist. So I think may works. I think if this sub-amendment is defeated, a sub-amendment that replaces must with should would provide, I think, maybe what both sides are looking for. It's just that this section effectively does not compel the minister. So to say that it does, or to say that it could, is I think, not really on point.
Mr. Fraser.
Thank you. Just with regard to the sub-amendment, while I appreciate the apparent inconsistency with what was stated earlier, first of all, I don't think it was that it cannot happen. I thought it was that it was unusual that the wording would be different. But more importantly is the fact that the previous use of the word may rather than shall in regards to the minister's discretion was dealing with setting out a regulatory scheme or framework with which the minister was able to make regulations. That's quite a bit different than this, which is clearly for one purpose, which is for a study to be commenced within 180 days. And I think therein lies the clear difference, and I would not support the sub-amendment.
Thank you very much. Mr. Falk.
Well, I think as a matter of consistency with what we've been doing thus far, when we take it and change the word must to may, because we don't want to give that definitive direction to the minister because it's got no teeth to enforce it. The same situation arises here. There's no means of enforcing this must. There's no means of being able to provide any meaningful impact for the word must. I mean, it's me. I don't think legislation in this House has often been used to give direction to a minister of the Crown, and not so definitively anyway. And I think we should stick with the wording that we used before, which was may, and then the minister can decide.
Thank you very much. So is there any further debate on the sub-amendment? Not hearing any. Mr. Warwa, you moved it. Do you want to close on anything? You're good?
It's clear.
So we're now moving, again, we're voting only on the sub-amendment, which is the motion to change, the sub-amendment is to change must to may. All those in favor of the sub-amendment? All those opposed to the sub-amendment? Defeated. Back to the motion in principle, or the main motion. So back to is there any further debate on the main motion? Not hearing any. Ms. Khalid, do you want to close on that one?
Just reiterate that we do need sound data to make good choices about issues that have really been brought up by the special committee as well as the witnesses that we've heard over the past few weeks. And I'm just looking forward to this being carried.
All right. Thank you very much. So we're going to move to the vote on the main motion. All those in favor of the main motion? All those opposed? Carried. So now we move to, let me see if there's anything else on this clause. There is not. So do we now vote again because there's a new clause 9.1 being created, or is that just deemed because the motion was the one that created it? We don't have to vote. That's right. So we do not need to vote again. We will move now to the review of clause number 10. So the first one is CPC 32, which is Mr. Viersen. So Mr. Falk, you won't put it forward? No, okay. Is there any member of the Conservatives that will put it forward? Not hearing any. Sorry, Mr. Viersen, your motion is not deemed moved then. Oh, okay. So, Mr. Cooper, you.
Oh, we decided again. Okay, sorry.
Okay, so it will not be. It will not be. This is not not put forward. And we will move to 32.1, or is that the same? Same. 32.1 is not going to be submitted. We will move to 32.2. Mr. Falk.
I'll move my own motion.
Yes, well, I'm thinking you would.
All right. Just to read it quickly, referred is to review them and the state of the palliative care in Canada and submit a report too. So that's in addition to the report that is going to be provided by this committee, is also to provide a report on the palliative care in Canada at that time as well.
Okay, receivable. Debate. Mr. Falk, did you want to speak at all to your motion?
Well, we've heard throughout witness testimony at committee here last week the need for a proper palliative care system here in Canada. We've heard that most Canadians don't have access to the standard of palliative care that one would expect that they should and are entitled to have. This government is committed to improving our palliative care system and has committed $3 billion to that end. We would like to make sure that that money is employed properly, and what better way to do it than to say we're going to have a review at the same time as a report is established here, and then that review can also tell us, it's like going to be like a bit of a report card to see if the Liberal government has done a good job in doing what they've said they're going to do. And as we've heard from witness testimony here last week, good palliative care system, when there's good palliative care options, the request and the need for physician-assisted suicide is greatly diminished. And I think that should be the objective of all of us around this table, is not to see if we can expand this particular exemption, but if we can actually minimize it. And we should get back to the point where Parliament respects the sanctity of life, which is what the Supreme Court said we should do. And so far, we haven't shown a whole lot of respect for life around this table, and certainly not the sanctity of it. And I think a review of our palliative care system at that time will move towards that.
Mr. Rankin?
I just want to speak forcefully in favor of the amendment. I think it's a very good one. Anyone who's attended any of the hearings at the Senate House Committee or at our Justice Committee would know how central palliative care is. We've heard the minister say that she hears that more than anything else. I'm entirely in favor of this.
Thank you very much. Mr. Biddle.
Thank you so much, Mr. Chair. I think all parties are in agreement that we should have good palliative care, and the minister has been vocal about her concern that Canadians don't have access to palliative care. But I think the purpose of this review is to focus on one particular issue, which is medical assistance in dying. And I'd be concerned that we'd water that down. The minister has committed to this. The government has acted in terms of $3 billion in new money in the budget, $3 billion, excuse me. So I don't see this as necessary, and I see it as watering down the purpose of the provision to deal and focus with medical assistance in dying.
Okay, any further debate? Mr. Cooper.
Well, with respect to Mr. Biddle's comments, I don't believe that the issues are separate. Palliative care is an essential component of end-of-life decision-making, and indeed many have said, and I believe the president of the CMA herself has said that one cannot truly consent to medical assistance in dying unless they have all options made available to them, including palliative care. We know that in Canada today, somewhere in the neighborhood of only 15 to 30% of Canadians have access to palliative care. So it is absolutely essential that we have a pan-Canadian national strategy with dedicated funding to ensure that Canadians not only have the option of palliative care, but that they have access to palliative care. And I think that it would be appropriate to include a review with respect to palliative care.
Mr. Hussain.
Yes. Just in response to that, I am of the view that palliative care is important to this discussion. However, the government has, as my colleague has stated, put money on the table with respect to palliative care and other health care related objectives. And in addition to that, the government has made it clear that they intend to sit down with provinces and territories to reach a health accord, which includes palliative care as a big portion of what they're looking at. So I think that's where this needs to be dealt with, not as an added item with respect to the review of medical assistance in dying. Thank you.
Mr. Fraser, and then back over here.
I'll pass. I agree with Mr. Hussain.
Mr. Worrell. Mr. Rankin.
Thank you. I agree with the comments made by my colleagues to both sides of me. And looking back to previous comments we've just dealt with regarding advance directive, regarding mental illness, immature minors, and we've dealt with conscience protection. The only issue that we're not dealing with in C14 is palliative care. And we heard, as has been shared time and time and time again, that an adult that is suffering, in a state of suffering, cannot provide consent if they do not have their suffering dealt with. And palliative care could be physical, it could be emotional, it could be depression. If you do not give someone palliative care, at least offer it to them, then that issue is not being dealt with properly, and you cannot properly administer medical aid in dying if palliative care is not part of it. So we've dealt with mature minors, we're dealt with advance directives, and the mental issue. This is the time where the government has an opportunity to deal with palliative care. And if the government does not support it, then they leave that issue off the table. Other than aspirational commitments, this is the opportunity to make it a specific commitment as they have the other issues. And I encourage the government to reconsider and support this. Thank
you. We'll just remember that the members of the committee are the government. But yes, Mr. Rankin.
Yeah,
Mr. Fraser.
I appreciate what Mr. Hussain said about the health accords and the fact that we're going to be dealing with that later, and I think that's a good point. But equally, I think that to study medical assistance in dying without studying palliative care seems to me to be something that would be very hard to do. They're interconnected. That's the evidence we've heard time and time again. So I think they do go together very well. And is it a boost, an argument which I appreciate isn't in order, but I'll just put it out there that I have, as you'll know, on page 134, some very specific proposals on palliative care that come out of the committee below. And if we could ground at least one reference in the bill to palliative care, I'm told procedurally it would be easier for those to be considered. So I have another additional reason for wanting this reference. I don't think it takes anything away. I think it only adds something that many Canadians would be pleased to see in the work that this committee would be doing in the future. So I think it adds a lot and takes away nothing.
I had Mr. Fraser next, and then Mr. McKinnon. Mr. Fraser?
I'll be brief. I was, when we're talking about the study that's supposed to be commenced within 180 days, dealing with advanced directives and the other two elements that we've heard from witnesses, those are essential to determining going forward how we're going to deal with those things, specifically linked, of course, to changes in the bill. That is not the same as palliative care and studying that, which a commitment's been made by the government that there is going to be funding for that, that it is going to be addressed, but the work is going to be done with the provinces. And so making it something necessary as far as a study of the medical assistance in dying wouldn't be appropriate in my view. It doesn't mean that it's not going to be part of it. In fact, I agree with the point that palliative care is an important part of the consultation process at the end of life. It's just about whether it would be appropriate to put it in this context, and I don't believe it would be. With regard to Mr. Rankin's comment, I agree that we are looking at getting some wording in the preamble. If there's a way that we can get it in the bill and bring it forward, I'd be happy to do that. But I wouldn't agree that it would be appropriate to put it in this part and make it necessary part of the medical assistance in dying review, which may or may not include that. But hopefully we'll be able to get it in the preamble in a fashion that everybody can agree on.
Ask a procedure. I'd like to ask one of our clerks a procedural question. My understanding is, because we're all trying to perhaps fit a circle into a square peg. My understanding was there's a way for the committee outside of the bill, if there's something that we feel strongly about but that doesn't go in the bill, to do a report or to do some recommendation back to the House outside of the bill, saying that we're interested in a subject, it doesn't fit in the bill, but we think that it should be studied or should be. What is the right way to do that if we were to decide that palliative care would be that way? So I just wanted the members of the committee to consider this. Because we started review of the bill early. We started a subject matter study of the bill before we actually moved to studying the bill itself. We could report the bill back and then separately, if there's an issue we think should be studied, as part of a subject matter study, could report back, for example, on an issue like palliative care, saying it's outside of the bill itself, but the committee deems it important that the minister consider that palliative care is an important alternative and work with the provinces. We could do something like that. I just wanted to let people know that it's something to consider as we go along. I think it's, this is an amendment that relates to an issue and we'll vote on it, but that is an option for the committee to consider. I'm sorry, I just wanted everybody to understand that. So back to the amendment itself. Mr. McKinnon.
I'm inclined to support this amendment. I think there's a lot of merit in the arguments on all sides. It's true we are committing money. We have made a commitment, and both of our ministers have made a commitment. But I don't think there's any problem with reporting at some point down the line on what's the state of palliative care. I don't think it will water down anything. So I will support this amendment.
Okay, thank you, Mr. McKinnon. Mr. Casey wishes to just advance, I guess, the position of the government. Mr. Casey?
The government's opposed to this.
Your microphone wasn't working. I couldn't hear you. Okay,
the government's opposed to this amendment. There is nothing to preclude the government from advancing its agenda with respect to palliative care, and the specific reference to it in the 5-year review adds nothing to the political commitment that's been made. And so it is something that I would argue is unnecessary, involves provincial jurisdiction, and would be the subject of negotiation as opposed to something that belongs in this bill.
Thank you very much. Further debate? Mr. Rankin.
I appreciate that, and I appreciate what Mr. Fraser said as well. Am I right in thinking, though, that there would be no reference at all in the bill to the words palliative care would not appear unless we're able to find a way to bring them into the preamble? Am I right in saying that the words palliative care would not appear anywhere in this bill? That's a question I'm asking the group. And I have to say, having sat through all of the Senate House Committee, I see Mr. Cooper nodding, and all through the Justice Committee, to not even see those words appear would be shocking.
Just to answer the question, the only place that I see any reference that would be similar is already in the preamble, where the Government of Canada is committed to develop non-legislative measures that would support the improvement of a full range of options for end-of-life care. If end-of-life care is synonymous with palliative care to some extent,
I'm not
that
sure.
would be the only place that it is currently in the bill.
I say again, therefore, that the words palliative care would not appear anywhere, and I don't agree that those words are synonymous. They're overlapping.
I didn't suggest that they were. I just said that that would be the only place I see anything similar. So I'm trying to remember. Mr. Falk was the one who moved this. Mr. Falk, I'm going to go back to you to close the debate.
Okay, thank you, Mr. Chair. You know, for all the reasons and perspectives the other side brought up there, and perhaps not supporting it, I think it just actually strengthens the whole notion that it's actually an imperative to have in here. You know, when I look at the scope, we didn't what the G3 government bill that we just put into this, or amendment that we just inserted into this bill, didn't have to be there neither. We chose to put it in there for the review. All of our witnesses attested to the relationship between palliative care and physician-assisted suicide. You cannot separate the two. They're so critically important to each other. And to say that we don't want to include in a report or a review the whole aspect of palliative care because it's an interjurisdictional issue, well, so will physician-assisted suicide. That'll be interjurisdictional as well, and it's going to require the same amount of collaboration with jurisdictions to get a decent report there as well. And this just helps to encompass the wholeness of what we're trying to do here, and that's to see whether this bill is really going to be effective, whether it's doing what we're asking it to do, and what are the influencing factors that have affected the performance or the activity of this bill. And palliative care is absolutely essential to that. To not review palliative care, you're not going to get a comprehensive review.
Thank you very much. So I think we've now finished the debate. So we're going to move to a vote on CPC 32.2. All those in favor? All those opposed? Carried. We will now move to CPC 32.3. Oh, ooh, that's weird. Something, I don't know what just happened with that one. 32.3. Mr. Falk, this appears to be yours, but I just need to read.
It's a follow-up.
It's the next line. Okay, I understand. It's the next line. Got it. Sorry.
It's actually quite simple. It's actually putting a parameter on what we just asked for. It's saying that within 6 months there should be a report from the time that the review has been initiated. Okay.
Understand. Receivable.
You know, and I don't know if I need to say more than that. It's a 6 month. I think 6 months is probably adequate to do a review and then provide a report.
Okay. Debate on 32.3. I'll give people a chance to study it because it's a new amendment and people may not have seen it in their package before. If there's anybody that wishes to enter into debate on this? Yep.
Mr. Falk,
of course.
Mr. Falk, can you, sorry, I'm just trying to, this is the first time I've seen this actually, so I apologize. Can you explain to me what it is, what the purpose of this is, just so I get it?
Okay, well, if you look at the report section of Clause 10, subsection 2, it says the committee to which the provisions are referred is to review them and submit a report to the House of or Houses of Parliament, of which it is a committee, including a statement setting out any changes to the provisions that the committee recommends. I'm suggesting we also insert on that 27th line a committee within 6 months after the day on which the provisions are referred to it, including a statement setting out. In other words, from the time that the report begins, within 6 months, they should be tabling that a report of that review to both either house or both houses.
Speaking to that, what C14 requires is that a report be submitted, but with no time frame attached to it. So it has happened in the 12 and a half years that I've been here, where to meet a requirement, a study will be initiated, with no continuum of that study, but they've met the requirement to initiate a study. And at times, if it's vague on when it has to be reported, sometimes it never is. And so I think this tightens it up. I think to say from when a report is started, it has to be submitted within 6 months. It takes away the vagueness, and then we would know that a report would be submitted. And there's a tangible timeline, and without that, it's left vague.
Understood. Mr. Fraser?
Can I ask the officials for if they have any comment on that? And I'm just concerned. I mean, the word may be designated or established, so setting up a committee possibly, and then we're saying that within 6 months they have to do something. I'm just wondering if there'd be a conflict in terms there between 1 and 2, and whether the officials would have any comment on that.
I think the wording that you have in Bill C-14 as proposed is fairly standard wording for a parliamentary committee report or a review to be undertaken. There's no question there are numerous bills that have been passed by Parliament, including in recent years, that include a requirement for Parliament to study an issue. And it's true that sometimes those studies don't get started because committees are in control of their own agenda. The matter has to be referred to the committee takes it on. And it's also true that sometimes a committee will undertake a study, and perhaps before the report is tabled, there's an election call or Parliament's prorogued, and there are rules to deal with that. And also my understanding as well is that when a committee undertakes a study, if they haven't completed the study within the time that the House requires the report to be completed within, that the committee also can go back to the House and seek an extension of the time in that situation. So I think there are opportunities within the rules that would allow and perhaps address the concern that has been raised by the member. But certainly the wording that you have in this clause as introduced is fairly standard parliamentary committee review.
Mr. Fraser, does that answer what you were asking?
Yeah, it does. Yeah, okay. I don't think I'll be supporting the amendment as worded. I worry about the binding effect of the language, and I realize that's the intent of it, of course. But I think if this is standard language for committees, and we're talking 5 years after a review, I think I'd prefer to leave it the way it is. Thank you.
Thank you. Mr. Biddle, did you have something? Let me just ask if there's any further debate, and then I'll come back to you. Not hearing any. Mr. Falk?
Can I just also ask a question of the department? An amendment like this, is this uncommon, where there's a time frame stipulated?
I don't think I couldn't comment. I'm not aware of it. I know that usually the debate has been, in my appearances before this committee over the years, it's been over how many years should pass before Parliament undertakes a review of the subject matter or the bill's provisions, as opposed to the completion of the report. Because I'm suggesting, based on my experience, that the parliamentary rules provide sufficient guidance to the committee and to the House in terms of how and when reports should be completed and or submitted, or extensions provided. But perhaps the clerk would have more particular information.
So when a committee is tasked with doing a review like this, it will automatically for sure generate a report?
The start of a report.
I mean, I can only comment on ones that I've been directly involved in, where reports have been generated and have been produced, and sometimes they call for a response by the government, and there are, again, rules that apply to how that is dealt with. The committee, when it undertakes a report and study, could ask for the government to respond. I think there are rules that are in play that when the Parliament has been prorogued, that it can come back and they can resume. A motion could be adopted to enable a committee to resume the work that was committed in the previous session without and just to adopt the evidence that's already been heard to that point. Certainly that's been my experience. Maybe there's been some, I'm aware of that happening in at least one parliamentary committee study. I think it was on prostitution quite a number of years ago.
Mr. Chair?
Yes, Mr. Falk.
My only concern with this motion is that if we're going to do the review, which we've committed to doing now, that there's actually a report. I would be flexible on the time frame, but we want a report.
I understand. That's clearly the intent of the motion.
If I'm still here, I'll make sure we get a report.
Nicely said, Mr. Fraser. Any further debate on this motion? Not hearing any. Let's move to a vote on CPC 32.3. All those in favor? All those opposed? Defeated. Next, we move to CPC 33, which is Mr. Viersen. Is there any Conservative member of the committee that wishes to move this on behalf of Mr. Viersen? Yes. Yep, Mr. Falk. Okay, Mr. Viersen, over to you.
We're still friends.
Well, now I'm checking.
Okay. Thank you, Mr. Chair. This amendment recommends, or would add the words recommends, and in the event of a serious breach of these provisions, provide a possibility of imposing a moratorium. This comes out of having followed how this similar legislation has played out in the Netherlands, just from my family's experience, essentially. They have brought in very similar legislation initially, and now we're hearing reports of several hundred people a year that are being euthanized without explicit consent. And so I would say that if we are in Canada going to have one person lose their life without consent, that would be one too many. And so I would like that after this review has been done, if there is significant breaches of these, they find that there is a lack of consent in certain cases, that they would impose a moratorium and therefore give them time to write up new law or change the law to ensure that we are getting consent in every case. So this just allows the committee to impose a moratorium.
Who has the right to do that? The committee certainly wouldn't have such a right. Are you suggesting that it's drafted so that the government has this right?
Yeah.
That the recommendation of the committee?
Yeah, the recommendation would allow them to impose a moratorium.
But who?
It goes, Minister of Justice at that point. I'm not sure. Again,
can I ask you to perhaps try to draft it in a way that I can receive it?
There you go.
Do you maybe want to work with the legislative clerk for some help? I find this vague and impossible to comprehend how the moratorium would best occur. And
here's where you go. There's nothing.
I'm not sure how it ended up in this section. It was my recommendation to the drafters was for the minister to be able to impose a moratorium in the event of findings from the committee, but I'm not sure exactly. That was my. I
don't even know where it goes.
But I'm not sure why it ends up here necessarily.
Am I on the wrong page? Then page 12 and.
Page 12 is the report of the committee report. It's the same section that we just
You're
amended.
adding it onto 2 there at the bottom.
It's part of the report.
Yeah, that's where I
recommends.
Yeah, and that's where you do raise a good point in that.
Out any changes the committee recommends the serious breach is providing for the possibility. But that's where I'm confused by the whole issue, because the committee may recommend to somebody to impose it, but it's still not clear who would actually be able to. How could I receive this if it would create a completely unclear element of the law. You know, unless you redraft it, I think we should perhaps move on. I defer to the mover.
Yeah, there isn't clear direction given as to where this is supposed to land.
Yeah.
And that's the issue here. And I think the intent of the motion is very good, that it would just give the minister a tool, that if the report would reveal that there's been some serious breaches procedurally in the administration of this particular bill, that the committee could, when reviewing the report, recommend to the minister that the minister impose a moratorium until the problems are fixed.
Yeah, I understand. Can I ask the department? I mean, because I'm having trouble following how this would logically conclude. Do you have any explanation of how this would work?
I think the only thing I think we could contribute at this point is to say that to stop it from being lawful, medical assistance in time, would take a legislative amendment to the criminal code.
Yeah, I mean, I really think that this sort of just doesn't work in this way. I'm sure if the committee finds there's serious problems, the committee will report there's serious problems, and any government that doesn't want to be politically embarrassed would have to act, if that solves anything. Ms. Khalid?
If I may, just to be fair to Mr. Viersen, considering this is the last item for Clause 10, before we start on the preamble, which I believe we're doing for tomorrow, if Mr. Viersen wants to go away tonight and think about it, maybe we could come back to this in the morning and vote on it as well.
It comes up with it would be really nice. The only thing that I would like to be able to do, and this is the reason that I want to do the break, is I want to be able then to review the law as amended through Clause 11 to make proper decisions on receivability on the preamble issues, and I can't do that unless we've completed the rest of the bill. So again, I look to you, Mr. Viersen. Let me just ask, because let's say I received it, debate. Is there anybody that wishes to speak to it as a motion? Can I ask for an unofficial vote? Who would vote in favor of this motion? Who would vote against? Mr. Viersen, are you willing to withdraw it? Thank you.
Yes.
Thank you very much. So thank you very much. So then what I suggest we do is let's have any deputy who wants to discuss Clause 11 as amended. Not hearing any, we'll move to a vote on Clause 11 as amended. All those in favor of Clause 11 as amended? Oh, Clause 10. Thank you so much, Mr. Falk. Clause 10 as amended. All those in favor?
I'm your vice. I'm here to make you look good.
You do. You always do. All those in favor of Clause 10 as amended? Any opposed to Clause 10 as amended? Carried. Now we move to Clause 11. So Clause 11, can everybody just look at the two sentences in Clause 11? Is there anybody that wishes to debate Clause 11? Not hearing any. All those in favor of Clause 11? Any opposed? Carried. So, ladies and gentlemen, thank you for your incredible cooperation today. We will reconvene at 4 o'clock tomorrow, and we will work on those preamble resolutions right now. Thank you so much.